who is taking necessary steps. Right. Who is taking necessary steps in order to, sorry, who is taking necessary steps with an intention. With an intention. Two conditions we have to follow. With an intention to, right, incorporate a company under the company set. Right? So A and B, they are promoters of this company. Right? Understood. Right. Then, thereafter, we have to consider about the duty of the promoter. Right. Now, when we consider the duty or duties of the promoter, the main duty is he owes fiduciary duty. Fiduciary duty towards the company and shareholders of the company. Fiduciary duty. What do you mean by fiduciary duty? Fiduciary duty. In a partnership, partners, they have fiduciary duties towards the partnership business as well as the other partners of the business. Fiduciary duty. Fiduciary duty means a duty based on trust. Trust. Duty based on trust. Right. Trustworthy. Right. Duty based on trust. It means, right? It means, right? Fiduciary duty means, right? Promoter cannot earn secret profits. Right? Secret profits. Secret profits, right? From the transactions with the company. Secret profits. Fiduciary duty is the duty of the promoter. That is the duty based on trust. Right? In other words, we can say he cannot earn secret profits from the transactions with the company. Right? Then it doesn't mean promoter cannot earn profit from the transactions with the company. Actually, he can earn profit, but cannot be a secret profit. That is the thing. Cannot earn secret profit. He can earn profit. How profits become secret profits? How profits become secret profit? Right. Yes. Right. If the nature of the transaction, the amount that he has taken as the profit, if it is not disclosed to the company and the shareholders, not disclosed, then it becomes secret profit. Just like here, we can say promoter can earn profit. Right? But the only thing is he has to disclose it to the company as well as to the shareholders. He must disclose. Right? Disclose those profits to company as well as to the shareholders. Understood? Only thing is he cannot earn secret profit. Secret. Can earn profit, but cannot be secret. So after disclosing the nature and the extent of the profit, he can earn profit, right, from the transactions in the company. Right. Only thing is secret cannot be a secret profit. Right. Now disclose to the company. and disclose to the shareholders. Here, in order to incorporate a company, we have to submit some documents, right? One document is Form 8. Form 18. What is it? Form 18 and 19. Right? Form 18. What is it? Is the on the page. Yes. Form 18 is the consent of initial directors to act as the directors of the company. Consent of directors. Right. Right. Form. Right. So today we are discussing about the promoters, right? I will put that here. So after incorporation, we have to submit some documents in order to incorporate the company. Among those documents, one document is Form 80 with the consent of initial directors to act as the directors of the company. Form 1 is the application form. First one is 16 name approval form. Form 1 application form. 18, 19. 18 is the consent of the directors, 19 is the consent of the secretary. Each year, so after incorporation of the company, the person's name in Form 18 will be appointed as the first set of directors. First set of directors. That is after incorporation. The person named in the Form 19 will be appointed as the first secretary of the company. Yeah. First set of directors appointed according to the Form 8. Form 8. Right. Then now, suppose this promoter, right, he has introduced these directors as the first set of directors in the beginning of the incorporation, right? Beginning of the company. The person named to Form 80, it is up to the promoters. Promoter means the person who is going to incorporate, right? Then, now, after incorporation, the first set of directors appointed. The person named in Form 18 appointed as the first set of directors. What do you think? Disclose the profits to this first set of directors, right, can be permitted as a proper disclosure. Yes? What do you think? Or in other words, right, now promoter is the person who is making necessary steps, right? And this person has named the persons in Form 18. Then after incorporation, they are appointed as the directors of the company, right? Promoter disclose the profits to this first set of directors, right? Now tell me, right? Here, can we treat this first set of directors as an independent board of directors? Independent board of directors. Promoter appointed. Right? So promoter name the persons to Form 18. Then, after incorporation, they were appointed as the percent of direction. Now, promoter disclose the profit to this board, the percent of directors. Percent of director can be treated as an independent board of directors? No. Understood? Because promoter, he named the persons to form a, and they appointed as the first set of directors. Therefore, this board of directors, percent of directors, right? Percent of board of directors cannot be treated as an independent. Compared independent. Compared independent boards. Therefore, this clause, disclose to the percent of directors is equal to non-disclosure. It is not valid. Right? Therefore, it is not valid. It is not valid. Right? Therefore, actually, therefore, here, promoter must disclose the profits to an independent board of directors. That is the requirement. Independent. Independent board of directors. Right. That is the requirement. Right. Now, promoter can earn profit, right, from the transactions with the company. But only thing is he has to disclose the profits to company and shareholders. Disclose to company means he must disclose the profits to an independent board of directors. Therefore, if he has disclosed the profits to the first set of directors who are appointed by himself, that is not treated as an independent board. Therefore, it is independent. Right? So, disclose to an independent board of directors. That is the requirement. Right? That is the requirement. Right? Disclose to an independent board of directors. Right? He can earn profit from transactions with the company, but he has to disclose it to an independent board of directors. So, percent of directors, percent of board of directors cannot be treated as an independent. Reason is promoters, he will appoint, so name the persons in forming, right? So, after incorporation, they name persons named in formatting will be appointed as the first set of directors. Therefore, disclose to that. The set of directors cannot be treated as an independent board. Therefore, it is not valid. Right. So that is the right the requirement. Right? What is the requirement? Requirement is he must disclose it to an independent board of directors. That is the requirement. Then to the shareholders. Here, shareholders, we must disclose to the shareholders. Here, shareholders, it means promoter has to disclose to the shareholders. Here, shareholder means existing shareholders. Existing shareholders and future shareholders. Right? It's close to existing and future shareholders. Right? He must disclose to existing and future shareholders. How he can disclose the profits to the existing shareholders? Existing shareholders. How he can disclose? Future shareholders, right? They will become the shareholders of the company future. In future, they are not existing shareholders. Future. And how promoter can disclose profits to future shareholders? Right? Like existing, first we can consider the existing shareholders. How you can disclose it to the existing shareholders? Right? That is, there are two types of meetings in a company. Right? There are two types of meetings. Right? Meetings. Right? We can divide into two. One is board meeting. Board meeting and shareholders meeting. Shareholders meeting. So we name it as general meeting, GM. Why they are holding meetings? Right? What is the purpose? Board meetings and shareholders meeting, right? They are holding meetings. Yes. What is the purpose? Vaccine, Kadamani, Adhyakshakaru, shareholders. Yes. In order to make decisions. That is the reason. Make decisions. Some decisions are taken by the directors of the company. Some are taken by the shareholders of the company. Right. At a meeting, right? Board meeting or shareholders meeting, if they have taken a decision, right? Then those decisions are named as resolutions. Another name for the decisions, resolutions. Resolutions. Resolution means decisions taken by the directors or the shareholders that right, the meeting. Right, resolutions. Right. So now, how promoter can disclose the profits to the existing shareholders, right? He can disclose them at a general meetings or shareholders meeting. Then it is right treated as disclose to the existing shareholders. Right. So he can disclose the profits to existing shareholders at a general meeting. That is the when we consider this, we get the shareholders meeting. There are two types of meetings, directors, shareholders. Right, shareholders meeting we can divide into two as AGM, and AGM. Annual general meeting and extraordinary general meeting. There are two types of annual, once in each calendar year. Shareholders meeting to be called. That is named as annual general meeting. So at the annual general meeting, they can declare dividends, shareholders. appoint new directors, right? Remove directors, right? Likewise, or approving the financial statements. So these decisions are taken generally, they are taken at AGM, annual general, right? EGM is suddenly, right? The company, the shareholders cannot wait next AGM. Immediately they must call shareholders meeting. So, right? Because of emergence, right? We have to call meeting, shareholders meeting. They are named as EGM, extraordinary general meeting. Extraordinary general meeting. Right? So at AGM or EGM, we can make, they can pass resolution, they can make decisions, right? They can pass resolution. Right? Now here, again, we can come to promoters, right? So existing shareholders, how we can disclose to the existing shareholders? We can disclose them to existing shareholders at a general meeting. Right? At a general meeting. And how promoter can disclose these profits to the future shareholders? Future shareholder. Right? If he is a future shareholder, actually they cannot attend general meetings. Only existing shareholders can attend general meetings. Like AGM only. Existing shareholders can attend. How he can disclose it to future shareholders? Yes. Future shareholders. Right? There is a way. That is, right? This is regarding to the public companies. Right? So when we consider the public company, right? Public company. Right? Public and private. Right. Tell me, what is the main feature with regard to public company? Why we name this company as public company? And the other times we name as private company. They don't have this special feature, private company. If we compare these two types of companies, public, why we name it as public? Yes. Yes. What is the main feature of the public company? Public companies we can further classify as listed and unlisted. So that one, listed and unlisted. Listed companies, they can trade their shares, securities on stock exchange. Right? Colombo stock exchange, they can trade their shares. Unlisted, they can't do that. They don't have that privilege. They cannot trade their securities, that is shares, privileges. They cannot trade securities on the stock exchange. So public company, what is the main feature of the public company? Right? Public company means these companies can invite the public to purchase the shares. Right? You can invite the public to purchase the shares. Right? Invite. Private companies cannot invite the public. Right? They cannot invite. So the shareholders are right, related parties, friends, family members. That's why we name it as private. Right? Private company. Right? If you consider the shareholders of the private company, they are related parties, friends, family members. Right? Therefore, this company cannot invite the public other way. They cannot invite the public to purchase the shares. Private company. But when we consider the public company, right, they can invite. The term is invite. Invite the public to purchase the shares. How public company can invite the public to purchase the shares? For the granting. What they are doing in order to invite the public. Sorry? They will, yes, publish. Right. They will publish, yes, that's correct. And advertisement. Then we want that. Advertisement in a newspaper or a magazine by inviting the public to purchase the shares. The publisher and advertisement. So the full page paper advertisement published by some companies. Right? By inviting the public to purchase the shares. The publisher and advertisement. So this advertisement, the paper advertisement, generally paper advertisement, this advertisement is named, can give technical term to this, it is named as prospectus. 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 Right? It is named as prospectus. Actually, it's an advertisement published in a newspaper. So this advertisement is used as prospectus. Right. Prospectus. So in the prospectus, this promoter can disclose profits, right, from the transactions with the company. Then it is considered as disclosed to future. Future means prospective shareholder. We can name the future shareholders as prospective shareholders. Prospective shareholders. Prospective shareholders. Then future shareholders. Right. Prospective. Prospective. Prospective shareholders. Right. So how promoter can disclose it to the future shareholders? Right. He can disclose them in the prospectus. And it is equal to disclose to the future shareholders. Right. Right. So this is the way how we can disclose it to the company and shareholders of the company. Right. Shareholders existing and future. Existing shareholders at a general meeting. Shareholders meeting. Future shareholders, right, disclose the profits in the prospectus. Those in the prospectus shareholders. Right, so this is the duty card for the promoter. Right, you cannot seek the profit. Therefore, right, he has to disclose and made of the profits earned from the transactions with the company to the existing shareholder. Sorry, before that, right, the company as well as to the right shareholders, existing and future shareholders. Right. So that is his view. Right. Thereafter, this is about the promoter. Right. Thereafter, we are going to consider about the contracts made by promoter on behalf of the future company. Right? They means taking necessary steps in order to incorporate a company sometimes. Right? He may engage in a contract with another party on behalf of the future company. Right? Then we are going to consider about the validity of the that type of contracts. Now, in law of agency, right? Last year, first year, right? We have discussed about the concept called creation of agency by ratification. Creation of agency by ratification. Creation of agency by ratification. Right? Now, in a particular case, right, there was a promoter of a hotel company. Hotel company. Right? Now, this person is going to incorporate a hotel company. Going to incorporate a hotel company under the company. Then, X is the wine seller. He informed the promoter that he had high quality wine at the lowest price. Then what happened? Promoter engaged him to contract with wine seller to purchase wine on behalf of the future company. Right. Now we can consider the transaction like this. I know suppose this is the time. Right? On 1st of January. Right? 1st of January, promoter engaged into contract with X. He engaged into contract with X to purchase wine on behalf of the future company. On behalf of the future company means on 1st of January, the company is not incorporated yet. It is not incorporated on 1st of January. Future company, on behalf of the future company. Right? Then thereafter, the company was incorporated. Suppose the company incorporated on 3rd of January. Incorporation of the company. Incorporation of the company, hotel company. Hotel company is incorporated on 3rd of January. Right? January. Right? 3rd of January. Company is incorporated on 3rd of January. Then thereafter, promoter informed the company that he has engaged into contract like this. Then what happened? Later on, the company, hotel company, has ratified the contract on 5th of January. Right? Hotel company ratified the contract. Ratified the contract. Then obtain the wine and consume. Right? Obtain the wine and consume. Then thereafter, right? Thereafter, after short period of business, this company was liquidated. Company was liquidated and company unable to pay to the wine seller. Right? Company did not pay to the wine seller the price of the wine. Then what happened? The company was liquidated. Therefore, wine seller filed an action against the promoter. Wine seller X filed an action against the promoter to recover the price of the wine. In order to recover the price of the wine. Then, under law of agency, right, the main concept is agent is not responsible for the contract. Right? Binding contract made between principal and third party. In this case, hotel and wine seller. Binding contract made between this hotel and the company and the wine seller. Right? Promoter is not responsible for the contract. No binding contract made between the agent and third party. Therefore, this promoter, right, his argument is, right, company was incorporated on 3rd of January. Then thereafter, the company has ratified the contract. What do you mean by ratify? What is the meaning of ratification? Ratification means, right, the company has given his approval for the contract. Approval. Ratification means approval. Approval is immediate. That is the meaning of ratification. Right? Promoter engaged into contract with wine seller on 1st of January. Then the company was incorporated on 3rd of January. 3rd of January. Then thereafter, the company, after incorporation, the company has given, right, their approval for the transaction made by promoter. Right? That is named as ratification. Right? Subsequent approval given by the company. That is ratification means subsequent ratification. What are the creation of agency by ratification? Right? This is the concept, right? This is the one way agency created between two parties. That is by ratification. Now, what the agency? Agency. We are considering about the relationship between agent and principal. There are two parties we can identify as agent and principal. Right. Agent and principal. Right? Two parties, principal, sorry, agent and principal. Right. Right. So agent and principal relationship may be created by several ways. There are several ways. Right? One way is ratification. Ratification. Very simple concept. Ratification. Ratification means subsequent approval. Subsequent approval. That is, you can consider this. Now, suppose there are two situations we can consider in order to identify the ratification. This concept. That is, now, first one is, now suppose, right? A, right? Or we can say, A never appointed B as his agent. Right? A never appointed B as his agent. Right? A never appointed B as his agent. However, right, he engaged into contract with third party, another party called C, on behalf of A. On behalf of A. What do you think? Right? Without giving authority. No authority given to B to engage in the contract like this. Right. No, without having any authority, he engaged in the contract with C on behalf of A. My question is whether A is responsible for the contract or not. Responsible or not? Not responsible. Understood? Because B, right, doesn't have any authority to engage in the contract on behalf of A. Therefore, A is not responsible. Right? And the second situation is, right? Second one, A has appointed B as his agent. But what happened? B engaged into contract with C by exceeding his authority. By exceeding his authority. Right? Or beyond his authority. He engaged in the contract with C beyond his authority. By exceeding his authority. Right? Now suppose A informed B, right, to purchase a loaf of bread for, right, 100 rupees. Maximum price able to pay is 100 rupees. That is the authority given to B. Right? A asked B to purchase a loaf of bread. The maximum price of 100 rupees. B engaged into contract with C to purchase a loaf of bread for 80 rupees. Tell me whether A is responsible or not. Maximum price able to pay is 100. B engaged into contract with C to purchase 80 rupees. A is responsible or not? Maximum price able to pay is 100. That is the maximum. B engaged into contract with C to purchase a loaf of bread for 80. A is responsible or not? Responsible. Why? What is the reason? This is within his authority. B engaged into contract with C within his authority. Therefore, A is responsible. Understood? But suppose B engaged into contract with C. B engaged into contract with C to purchase a loaf of bread for 150. 150 rupees.
Yes.
150. Right. Now tell me whether he is responsible or not. Not responsible. Why? Yes. Because B has exceeded his authority and engaged into contract with C. Exceeding authority means there is no such authority. There is no such authority. Maximum is 100. Right? No authority to purchase 150. Therefore, A is not responsible. Understood? So here, in second situation, we can identify B has exceeded his authority and engaged into contract with C. Therefore, A is not responsible. In first situation, B doesn't have any authority because never appointed as an agent. Never appointed as an agent means doesn't have any authority. Right? So, even if we engage into contract with C on behalf of A, it's not responsible. Never appointed B as an agent. Here, the properly appointed agent engage into contract with C beyond his authority. Therefore, A is not responsible. Two situations we can recognize. Right? Now, suppose B engage into contract B engaged into contract with C on 1st of January. 1st of January. But A is not responsible in these two situations. But A is not responsible. But what happened, ratification, after B engaged into contract with C, that is after 1st of January, so there is the time, right? After B engaged into contract with C, A has given his approval. Suppose 3rd of January, A has given his approval. Approval for the contract. Right? Approval for the contract. This is named as subsequent approval. Subsequent approval. Right? This is after the contract is made. That is the meaning of subsequent approval. A has given his approval for the contract. Understood? So approval is given on 3rd of January. After we engage into contract with C. We engage into contract with C on 1st of January. Later on, right? A has given his approval. Why? Right? A must give his approval. Why he has to give his approval? Reason is that on 1st of January, he did not have such authority. Right? On 1st of January, we never appointed as a name. Never. In my second situation, on 1st of January, we did not have authority to engage into contract to purchase 150. No authority. Right? In both situations, no authority on 1st of January. Therefore, later on, he must give his approval for the transaction. This is named as ratification. Subsequent approval or ratification. Ratification. Right? This concept is named as ratification. Subsequent approval. Ratification. Right. Now what happened? Once B has given his approval on 3rd of January, he has given his approval on 3rd of January, then we can say, right? By ratification, agency created between these two parties. Agency created. Agency created between A and B. Agency created. Right? Agency created. So this is a one type of creation of agency. Right? Creation of agency by ratification. Then after creating an agency between A and B, then what happens? A is responsible for the contract. So after giving approval, A responsible for the contract is C. Now earlier he is not responsible. Right? Under this one. And this one, A is not responsible. But after giving his approval, then binding contract made between A and C. Right? Agency created between A and B. Then A is the principal. We made as principal. And B is the agent. And C. Right? After creating an agency, C is treated as the third party. Third party. Then what happened? Binding contract made between principal and third party. Principal and third party. Binding contract made between these two parties, principal and third party. A and C. Between A and C. Therefore, the agent is not responsible. B is not responsible. B is the agent. B becomes the agent, then he is not responsible for the contract. Contract made between principal and third party. That is the argument made by the promoter in this case. Right? And now we can consider this is the concept called ratification. The mother can get it. Now here what happened? In this case, promoter is a promoter. Engage into contract with wine seller on behalf of the future company. That was happened on 1st of January. Right? Promoter engage into contract with wine seller on 1st of January. So on this date, the company is not incorporated. Then later on, the company was incorporated on 3rd of January. Right? Then after incorporation, company ratified the contract. 5th of January. Company ratified the contract. After ratification, right? Agency created between company and promoter. Agency created. Agency created means, according to the ratification, agency created. After ratification, agency created between promoter and company. Agency created means binding contract made between wine seller and the company. Right? Contract made. Contract made between wine seller and the company. Right? Then what happened? The company was liquidated. Then wine seller, in order to recover the price, wine seller bring an action against the promoter. Then promoter said, you cannot file an action against me. Why? The company, after incorporation, company ratified the contract. Therefore, by ratification, agency created. And an agent, company is the president. You are the third party. So according to the concepts of law of the agency, binding contract made between, right, principal and the third party. Right? Company and wine seller. Third party is the wine seller. Right? Therefore, you cannot file an action against me. Right? You may have to file an action against the company before it is liquidated. Right? So that is the argument made on behalf of the promoter. He said, I am not responsible. I am an agent. Company is the principal and you are the third part. So binding contract made between yourself and the company. They have to bring an action against company, not against me. I am not responsible to pay wine. The price of the wine. That is his argument. Then actually what happened in this case? Yes. Whether the argument made on behalf of the promoter is accepted or refused to accept. Right? Very important case. Right? With regard to the company's corporate law. This is very important case. Right? Actually, in this case, the case is Galle versus Baxter. Right? Galle versus Baxter. Galle versus Baxter. In this case, court held, right? After incorporation, very important, right? The court, okay. So in this case, court held, after incorporation, the company ratified the contract. Company ratified the contract. Right? In this case, court held, even if the company ratified the contract after incorporation, this ratification is invalid. Not valid. Ratification is invalid. Right? Therefore, there is no valid ratification. If there is no valid ratification, then what happens? No agency created between promoter and company. No agency created. No agency created means right? No binding contract made between principal, you can't say principal, company and vice seller. No binding contract made between buying seller and the company. No valid contract. Then who is responsible for the price of the wine? Who is responsible to pay wine, the price of the wine? Promoter. Promoter, he himself responsible to pay wine to third party. So from third party, promoter is responsible to pay price of the wine to the wine seller. We can't say third party, right? There's no agency. Agency is not created. Right? No ratification, therefore no agency created. Therefore, we can't identify agent principal third party relationship. Therefore, promoter, he himself responsible to pay the wine seller. Right? Therefore, the wholesale wine seller can file an action against promoter in order to recover the price of the wine. Right? So, argument made on behalf of the promoter is he is not responsible because the agency created. Therefore, the binding contract made between company and wine seller, he is the agent, promoter is the agent. Therefore, he is not responsible for the contract. Right? He need not to pay the price. That is his argument. But what has ratification is invalid. Ratification is invalid means no agency created between promoter and the company. No agency. Therefore, no binding contract made between right wine seller and the company. No binding contract. Therefore, the person who engaged into the contract is personally responsible. Pay the price of the wine. Therefore, both here, right? Promoter is personally responsible to pay the price of the wine. Right? Therefore, actually, what is the legal issue arose in this case? It's what is the main legal? Actually, because of the legal concept, court here, this ratification is invalid. What is the main concept? Yes, that is right. In order to so on the ratification, right? On the ratification, these dates are very important, right? Promoter engaged into contracting wine seller on 1st of January. Then the company was incorporated on 3rd of January. After 2 days. Then ratify the contract on 5th of January. Right. Now, after ratification, after ratification, I told you, right? Agency created between promoter and company. Between promoter and company. Agency created. But agency created means binding contract made between wine seller and the company. Right? Binding contract made between wine seller and the company. Right? Binding contract made between wine seller and the company. From which date binding contract made between these two parties? Yes. From the beginning. So we have learned, we can say, right? Right? Ratification has retrospective effect. Retrospective effect. Retrospective. Prospective, retrospective. That is the opposite of prospective. Prospective means future. Retrospective can it has retrospective effect. Right. Now, when company ratified the contract on 5th of January. Once it is ratified on 5th of January, it is affected to the past. Past means 1st of January. Right? 1st of January. Therefore, after ratification, binding contract made between wine seller and the company from the beginning. From the beginning means from 1st of January. From 1st of January, binding contract made between principal and third party. Principal and third party. But here, principal is a company. The company is incorporated on 3rd of January. Therefore, on 1st of January, there is no such company available. There is no such company available. So, if the company is not available on 1st of January, how? Binding contract formed between company and another party. Right? Company, right, is not available on 1st of January. Understood? Therefore, right, the company came to an existence on this date. 3rd of January. This is the date. This is the birthday of the company. This is the birthday. Right? On 1st of January, there is no such company. There is no such company. Ratification has retrospective. Once it is ratified from the beginning, binding contract made between principal and third party. Right? However, on 1st of January, the company is not available. If the company is not available, they right unable to form a binding contract. Right? Understood? Therefore, right? Therefore, court held, right? If the principal is a company, right? And if it is not incorporated on 1st of January, then unable to form a binding contract. Unable to form a binding contract between this company and the another party. Therefore, that's why court held, even if the company after incorporation, this contract is ratified, this ratification is invalid. Actually, the only thing is ratification has retrospective, right? So, from the beginning, right? After ratification, agency created, and binding contract made between principal and third party from the beginning. Right? From the beginning, binding contract made. Binding contract made between company and wine seller. Wine seller. Right? Binding contract made between company and wine seller. Right? However, in this case, it is very clear. On 1st of January, there is no such company. Because the company is incorporated on 3rd of January. 3rd of January. So on 1st of January, there is no such company. So if the company is not available, how binding contract made with wine seller? Unable to form a binding contract. That's why court held, right? This company, even if the company has ratified the contract later on, this ratification is invalid. Ratification is invalid. Right? No agency created by ratification. Therefore, no binding contract made between company and the wine seller. Therefore, the promoter is personally responsible to pay the price of the wine. Understood? So there is a case, right? Item as Keller versus Daxton. Keller versus Daxton. Right? Or we can say, we can summarize this concept. What is the summary? Summary is, right, in Keller versus Baxter case, and court held that the summary, talking about you for the and you pay. Right? Right? In this case, court held, right? The company cannot ratify ratify its pre-incorporation contract. It's the company cannot ratify its pre-incorporation contract. Understand? This is the concept. This is the right. The theory introducing this case, the company cannot ratify its pre-incorporation contract. Now, this case is also pre-incorporation contract. The company incorporated on 3rd of January, contract made on 1st of January. That is prior to incorporation. Understood? Pre-incorporation, prior to incorporation. Therefore, if it is a pre-incorporation contract, company cannot ratify it. Reason is ratification has retrospective effect. Right? It is affected to past. Therefore, from the beginning, binding contract made between company and third party. So, if the company is not available on 1st of January, then unable to form a contract. Therefore, the company cannot ratify its pre-incorporation contract. Understood? Therefore, who is responsible? Promoter is personally responsible for the pre-incorporation contract. Understood? Promoter has to pay money. Right? Promoter has to pay price of the wine. That is the decision given in PCS. Right? Elder versus taxpayer. Right? Is it clear? Now, this is according to the common law. What do you mean by common law? Common law. Common law. What do you mean by common law? Under lifting of veil of incorporation also we have discussed the legal procedure under the Companies Act. According to some sections, we can lift the veil of incorporation and according to common law concepts. Right? Case law principles. Right? So common law means according to the case. Common law, it means according to the case laws. Case laws. Right? In corporate law, common law means case laws. Right? Case laws. So this is the case, Galle versus Maxwell. In according to this case, the company cannot ratify its pre-incorporation contract. The contract was made prior to the incorporation of the company. Then after incorporation, company cannot ratify this pre-incorporation contract. Even if it is ratified, the ratification is invalid. No agency created. Therefore, no binding contract made between company and third party. Right? Then the promoter is personally responsible for the contract. So that is the concept recognizing the common law. Right? Or according to case laws. Right. Now, according to the common law, is pre-incorporation contract. Right? After incorporation, that company cannot ratify it. Right? If the promoter is personally responsible for the contract, then what do you think? The promoter is encouraged to engage into this type of contracts or discouraged to engage into this type of contract? Discouraged. Even if this contract is right very important to the company, future company, then the promoter is discouraged to engage into this type of contract. Right? Because he is personally responsible for the contract. That is the reason. Right? But therefore, according to the concepts recognized under common law, right, it has discouraged the promoter from engaging in pre-cooperation contracts. Right? Discouraged. Right. Therefore, when introducing the Companies Act in 2007, this is number 7 of 2007, right? There is a provision, right? Introduced to the Companies Act. Section introduced. Right? In order to encourage the promoter to engage into this type of pre-cooperation contracts. Right? That is section 23. This is the position under Companies Act. Companies Act. According to the Companies Act, there is a provision to encourage the promoter to engage into pre-cooperation contracts. Right. So section 23. 23 says, right? The wordings are very important. It says, notwithstanding anything to the contrary in any law, notwithstanding, right? Notwithstanding anything to the contrary in any law. We need not to consider the provisions in any law, notwithstanding anything to the contrary in any law, right? Any law. By common law. Right? We need not to consider the common law concerns, notwithstanding. Right? Notwithstanding anything to the contrary in any law. Companies Act says section 23, right? Pre-cooperation contracts may be ratified. May be ratified. Right. What is the word used here? May be ratified. Not shall be ratified. May be ratified. Pre-cooperation contracts may be ratified. So after incorporation, the company, right, may be ratified the pre-cooperation contract may be ratified by the company after incorporation. May be ratified. Right. Notwithstanding anything to the contrary in any law. Right? Any law. It refers to, right? Any law means common law, statutory law, whatever. Any law. Pre-incorporation contract may be ratified. Then further it says after ratification, right? After ratification. So after ratification, this contract is valid and enforceable. Valid and enforceable. Valid and enforceable. Enforceable as company was a party to the contract. As company was a party. At the beginning. Right. At the beginning. What is it? Right. They are to find. Right. Section 23. It says, right, pre-incorporation contracts may be ratified. Word is very important. Pre-incorporation contracts may be ratified. Right, after incorporation, pre-incorporation contract may be ratified. After ratification, it is valid and enforceable as company was the party to the contract. Now, 1st of January, right, it is valid and enforceable as, right, the company was the party to the contract on 1st of January. Right? But actually on 1st of January, the company is not incorporated. It was not incorporated. It was incorporated later on, 3rd of January. However, the statute says, Companies Act says, section 23, it says valid and enforceable. After ratification, valid and enforceable as company was the party to the contract at the time. Same as it is valid and enforceable. That is the position introduced in the Companies Act. So to encourage the promoter to exit into the incorporation. Understood? That is the position under the Companies Act. Right. I didn't have a thought break. After that, message mount
Aleo pago mo. Ana, ali sempre. Sempre. Okay, fine, good idea.
One because they don't. What you don't think? I can work the minimum. Like something. We'll deal with it. What you're done. You can get out. Something. The media. And the what gets it out of the thank you. I shall be able to do it. That's why we go on. There are two sides of the test. Game to the love day for Janika, some happening. Oh, you are no idea. I think that's standing in the book. For example, they have no face of man or getting house of the vision part. Been there on the biggest one. Maybe reputation. That's the way it back to the candidate that someone else about 15 or something. ठीक है पूर्ण में अवलोकन था विदा सब Now, read the section 23. Right? Pre-incorporation contracts may be ratified. May be ratified. And after ratification, validity and enforceable as the company was right, part to the contract. Right. Now here, another two types of risk we can identify with regard to the third part who is engaging into pre-incorporation contract. One is now when you consider the pre-incorporation contract, one risk is now is the time. Is the time when promoter engage into contract with third party on 1st of January. Right, 1st of January. Then after they engage into the contract on 3rd of January, this contract is ratified. After they engage into the contract, first the company is incorporated. So we have to consider about the incorporation. And thereafter, after incorporation on 5th of January, the company has ratified the contract. When according to the Companies Act, it says may be ratified. After ratification, validity and enforceable. But we need not to consider about any other right concepts recognized under any other law. Not understanding anything to the contrary. Is validity and enforceable. But when engaging into this type of pre-incorporation contract by the third party, right? One risk is, right? If the company is not incorporated, so the third party engages into contract with promoter on 1st of January, right? Then if the company is not incorporated, then what happened to the third party? And the second risk is, right? That is, here, when we consider the words, it says may be ratified. Therefore, ratification or not, it is up to the company. Company can either ratify the contract or refuse to ratify. It doesn't say, right? Shall pre-incorporation contract shall be ratified. It says may be ratified. The choice is given to whom? The company. Therefore, after incorporation, even after incorporation of the company can refuse to ratify. Refuse to ratify. Right? Whether it is incorporated or not, it's one risk. It is not incorporated, then what happens? Right? And suppose the company is incorporated, but company refuses to ratify it. What happens to the third part? So there are two risks we can identify with regard to pre-incorporation contracts, right? In relation to third part. Right? So how Companies Act has overcome these risks, right? in relation to third party. That is the next issue, right? So here, now in loan contract, we have discussed there are two types of terms, right? Again, loan contract. There are two types of terms. We can divide into two. Terms divided into two as conditions, and warranties. Right? Condition means it means vital terms which are going to the root of the contract. Very important terms are conditions. Lesser important terms are warranties. Right? So if a condition is violated, then two remedies, two reliefs available to the innocent party, that is claiming damages and cancel the contract. That is regarding conditions. And if it is a warranty, then innocent party can claim damages. He can claim damages. Right. Now, companies access. We have to protect the third party. Right? If he is engaging into a pre-cooperation contract, then we have to protect the third party as well, not only the promoter. Encourage the promoter and protect the third party. There are two options, right? Option actually two duties, right? In order to promote the encourage the promoter and protect the third party. The reason is if the company is not incorporated, then what happens to the third party? Right? The company is incorporated but refuses to ratify the contract. So it says may pre-cooperation contract may be ratified. So if the company refuses to ratify, then what happens to the third party? How companies can protect the third party? Right? That is the way. This is the way, right? Companies access when promoter, that is the important parts, right? When promoter engaged into a contract with third party, right? When promoter engaged into contract with third party on behalf of the future company, there is pre-cooperation contract. When promoter engaging into pre-cooperation contract with third party, he will give two warranties to third party. Promoter will give two warranties. Warranties to the third party. Two warranties. By engaging into pre-cooperation contract, promoter will give two warranties to third party. First one is with regard to incorporation. What is the warranty? Company will incorporate in the near future. That is the warranty given by the promoter to the third party. Right? Company will incorporate. The first warranty is company, two warranties. First one is with regard to incorporation. So the warranty given by the promoter, the company will open. The near future. right? Or stipulated time mentioned in the contract. They can mention during this period, right? Company will incorporate. Right? Promoter can mention. Right? And the second warranty is with regard to ratification. After incorporation, the company will ratify the contract. Will ratify. Ratify the contract. So these are the two warranties given by the promoter to the third party. Promoter, these warranties are given to third party. Third party means the person who is engaging in the contract will promote. Understood? Then what happened now after the contract was made? Suppose the company is not incorporated. There's a risk, not incorporation. Then what happens? Third party can file an action against promoter in order to recover damages. Right? Third party can bring an action against the promoter for damages. Therefore, actually, if the company is not incorporated, promoter is responsible to pay damages to the third party. So that is the way how, right, companies have given protection to the third party when engaging into the incorporation. And the second one, we can identify, right? That is, the company is incorporated, but refuse to ratify the contract. Refuse to ratify the contract. Then what happens? That is breach of a warranty. Promoter has violated that warranty. What is the warranty given by the promoter? After incorporation, company will ratify. If this was not happen, that is violation. Then promoter is responsible to pay damages to third party. Understood? By engaging into pre-incorporation contract, right, by the promoter, he will give two warranties to the third party. One is, the first one is with regard to incorporation. So this is pre-incorporation contract. Thereafter, company is incorporated or not. So the warranty is given by the promoter, company will incorporate. Right? If the company is not incorporated, then he is responsible to pay damages. And the second one, second warranty, because of the word, may be ratified. May be ratified. Right? So it is up to the company. Company can ratify or refuse to ratify. The company refused to ratify after incorporation, did not happen. Right? Promoter has violated this second warranty. And it is responsible to pay damages to the third one. So by introducing these two warranties, right, actually the protection is given to the third one. And one is encourage the promoter. Section 28 says may be ratified after ratification, then no issue, valid and enforceable. Right? However, there's a risk part of the third party who engage into pre-incorporation contract. One is with regard to the incorporation of the contract. Second one is ratification. After incorporation, whether the company ratify or not. And so, in order to protect the third party, two warranties introduced. So, promoter is giving two warranties to the third party. Will incorporate in writing. Right? If there is any violation, the promoter is responsible to pay damages to the third party. Understand? Right? So, this is regarding the pre-incorporation contract. Right. So actually now why we are considering two positions, one is under common law and the position under Companies Act, right? Then we can very easily identify what is the what are the differences introduced under the new Companies Act, right? So according to common law, cannot. Right, pre-incorporation contracts, the company cannot ratify its pre-incorporation contract. That is the common law concept introduced in the Galle versus Baxter case. Thereafter, 2007, under the new Companies Act, he not reduced. right? So we have a so under this new Companies Act number 7 of 2007, right? New section introduced in order to encourage the promoter to engage into pre-incorporation contract. And by encouraging the promoters, some protection is given to the third party as well, right? By introducing two warranties with regard to the pre-incorporation within the postal market. Therefore, pre-incorporation contracts may be verified after verification. It is valid and enforceable. However, by engaging in pre-incorporation contract, promoter is giving two warranties to third party regarding incorporation and verification. If there is any violation, the promoter is responsible to take damages to the third party. Right? So that is about the pre-incorporation contracts. Yes. Question. Yes. Right. So Galle versus Dexter case at section 23. Right. So these are the most important areas regarding promoters. Right. The tenders monthly.